Hi, my name is Mark Addis. I am an attorney licensed to practice law in the state of Maryland. I've been practicing law since 1980 for approximately 37 years. My primary areas of practice are personal injury, car accidents, and workers' compensation. The purpose of this video today is to discuss what happens after your case has not been able to settle with the insurance company and it's necessary to file suit and go to court. So today we're going to discuss those procedures. All right, so at this point your case is not settled. What will your lawyer do next? The first thing he's going to do is file suit. What does that mean? He's going to prepare a pleading called in Maryland a complaint, as well as more likely than not an election for jury trial. If it's going to be in the circuit court, if it's in the district court, he's just going to file a statement of claim outlining what your claim is about and how much money he's demanding that the case be worth. Once the complaint's filed, then the person who's listed as the defendant, meaning the person you're suing, has to be served with the papers. So the complaint is filed with the clerk's office. The clerk's office stamps the papers and then prepares a summons, which is sent back to the lawyer, and then the lawyer either gets the sheriff or the post office to serve the other party, or he will hire a private process server in order to speed up the process of trying to get service. Service means that the defendant has a right to be served with the papers, handed the papers, and given notice of the suit. Once the defendant is served, he then has a period of time in which to file an answer. Typically that period of time is somewhere between 15 and 30 days. The answer is typically filed in a car accident by the defendant's insurance company, so he should turn those papers over to his insurance company so he can file an answer. If he doesn't have insurance, then he should file an answer on his own. Failure to file an answer can result in a default judgment in favor of the party who filed the suit. With the papers that are served on him, he'll typically get a set of interrogatories, which are a set of questions that the defendant has to answer. In the district court, that would be 15 questions. In the circuit court, that would be 30 questions. Those questions are typically answered by their lawyer. In addition, when the defendant files an answer to this complaint that's been filed, he will then send that to your lawyer, meaning the lawyer that represents you, the injured party. With those answers are a set of questions for you to answer, interrogatories for you to answer, either 15 or 30 questions. Typically, those questions have to be answered either within 15 or 30 days. They have to be answered honestly and completely. Once the interrogatories have been answered, typically a request for production of documents will be filed. Those can be any length, asking for any documents that the other side thinks are relevant in order to prove or disprove the case, so that the person who's filing the complaint files a set of requests for production of documents. The person who's being sued files a request for production of documents. Once all the documents are in, once all the questions have been answered, the interrogatories, the next proceeding is normally depositions are taken. I have a separate video on depositions, but basically a deposition is taken in one of the lawyer's offices or in a court reporter's office where they can ask basically anything they want about the people involved in the case. They also may depose the witnesses, the police officer, the doctors, any of those people can be deposed, anyone that's involved in the case. After the depositions are taken, typically the court will submit a scheduling order that says when things are going to take place. The scheduling order includes when the depositions and interrogatories are going to have to be completed, when a settlement conference would take place, and when a trial will take place. During this entire time, obviously settlement discussions can continue as the parties get more information. Getting closer to trial, there's going to be a settlement conference. Now in Maryland, the courts also require a private mediation where the parties get together with a private mediator that they have to pay for in order to try and settle the case. The courts like to encourage settlement, so they're going to give you ample opportunities to do that. The first opportunity, other than when you were dealing with the adjuster and other than any time, is when you go in front of this court mediator. His sole purpose is to try and bring the parties together to try and settle the case. Typically that'll take an hour or two. It's usually done in some lawyer or mediator's office, and it usually has to be paid for by the parties. If that mediation falls through, then the next proceeding is normally a settlement conference. At a settlement conference, they're typically done by a settlement judge. He's going to do similar tactics that were used by the mediator, except judges usually have a lot less time. If you're lucky, you'll get a judge that will spend some time to try and get the parties to agree on certain things, and even if the case can't be settled, perhaps some of the issues in the case can be resolved so that those don't have to be tried at the time of trial. If you're unlucky, you're going to get a judge who's just going to ask you, were you able to settle the case? And if you say no, then he kicks you out of his office and move on. In some of the jurisdictions, the trial date is scheduled once they realize you can't settle the case. In other jurisdictions, the trial date is set in advance. Next proceeding, if the case hasn't settled, is going to be your trial. At the trial, you're going to come to court on the day the trial is scheduled. Sometimes you go to court on the day the trial is scheduled, and the court has scheduled 50 other trials on that date, and they only have 3 other judges, and your case may be postponed. If you're lucky enough that there's a court available, all the parties are available, then the case will go forward. Now we're going to go over what happens at an actual trial. First thing at a trial, especially if it's a jury trial, you got to pick the jury. This is done through the process of voir dire. Voir dire means that each lawyer is going to submit a set of questions for the judge to ask the jury so that the parties can get to know the jurors a little bit. In Maryland, the questions that you can ask are relatively limited, so that we can't get all the information we want, but we get a pretty good idea of what the prejudices and the likes are of these particular jurors that are in front of us. We also get some general information about where the jurors live, what their name is, how old they are, and whether they're married or single, and their educational background. This all is factored in by the lawyers to decide what kind of jurors they want. After the judge asks the voir dire, we go up to the bench, and there may be some jurors that can be stricken for cause, meaning they have come up, answered certain questions. We bring them up to the bench, and if the juror sounds like they will not be able to make a fair decision based upon the question we've done, we can ask the judge to strike them for cause. If they're not stricken for cause, then after we go through the whole process of going through each one of the jurors, we then pick a jury. Each lawyer is allowed so many strikes. So in Maryland, we get 4 strikes, and sometimes you get some additional ones to add alternates. At that time, you can then strike out, based upon your own discretion, the 4 jurors that you think would not be helpful to your side of the case. The other lawyer does the same thing, and from the people that are left, the judge will pick from the top or from the bottom of the list the jurors that are going to sit in your case. Now, every jurisdiction has a different amount of jurors, and in Maryland, it's 6 jurors that decide a civil case. Sometimes they add 1 or 2 alternates. The alternates will sit in on the entire case. However, they will not make a decision in the case unless one of the 6 jurors is dismissed from the case or fails to show up at the time it is to make a decision. Then the actual trial starts. Each lawyer will do an opening statement. Your lawyer will do a statement representing you as the injured party, outlining some information about you and what it is he intends to prove in his particular case, so that the jury at least has a roadmap for what's likely to happen. Then the defense lawyer will get up and do his opening statement, outline his defense, and the roadmap for the jury to follow with regard to his defense. Then the plaintiff, being the party that brought the action, will then call its witnesses. Those can be called in any order that the party wants to call them. Once a witness is called, the plaintiff's attorney, meaning the person who represents the person that was injured, will ask questions. When he's done, the defense lawyer will have a right to cross-examine those witnesses. After the cross-examination is over, if the plaintiff's lawyer wants to follow up on any of the points that were brought out on cross-examination, he has a right to ask questions again, and then that's basically it, and that happens with each witness. If it's an injury claim, doctors will be called to testify, and they will give their testimony. Or they can be done by videotape. So in a auto accident claim, there's two ways to bring the doctor's testimony in, or any of your experts. You can have them come into court and testify, which can be extremely expensive because the doctors want to be paid for taking their entire day off. You may spend $5,000 or $10,000 or more just for the doctor's deposition. Or you can do a video deposition of the doctor where it's done in advance of court. We typically do it at the doctor's office. It may take an hour, hour and a half, and that's it. And the doctor's charges, therefore, would be a lot less than if he actually had to take the whole day off to testify in your case. So at trial, if we took the video deposition, the doctor would actually testify in that case through the video screen. We'd bring a TV in, and we'd have a screen, and then the jury would watch the doctor testify through that way. Once the plaintiff has provided all of their witnesses, usually motions are taken where the defense lawyer files a motion saying the plaintiff hasn't proved their case, and if the judge has to make a decision whether by the preponderance of the evidence there's at least some evidence that's been presented that supports the plaintiff's position. If there is, the case will go forward. If there isn't, the case will be dismissed, or certain issues will be dismissed. After that, and probably after lunch, then the defendant will put on their case. Same thing. They will present their witnesses. Then your lawyer will have an opportunity to cross-examine those witnesses. They'll put on their doctors if they have any, or put on their videos. At the end of the defendant's case, then motions will be made, again, saying that whatever the defendant put on isn't enough to go to a jury on those particular defenses, or now the judge has to decide, now that he's heard all of the evidence, whether there's enough for the plaintiff to go forward, meaning the person that was injured. The standard at that point is a lot more strict than it was initially. Then, after that, the next thing that takes place is jury instructions. Jury instructions meaning the jury doesn't really know the law in the particular area. They may think they do, but there are certain laws that apply in every single case. And at that point, the lawyers get together a set of instructions they want given to the jury. They give them to the judge. The judge will go through those with the lawyers, and then eventually the judge will give whatever instructions he thinks are appropriate. Those instructions are read to the jurors, and after that, both lawyers then get up to do closing argument. Because the plaintiff is the one bringing the case, meaning the one that was injured, his lawyer goes first, and he outlines now, instead of whatever the roadmap of what he expected to prove, he now goes through the evidence to show you what he has in fact proved, as far as who was at fault and what injuries the claimant has, and then giving a demand for a certain amount of money and some explanation for why he's asking for that amount of money. Then the defendant gets to do his closing argument, and again, he's going to give his version of how he saw the facts and what facts he thinks are important and what facts he thinks aren't important, and make an argument as to why the plaintiff is either not entitled to anything, or that the plaintiff was contributorily negligent, or whatever his defense is, he's going to make that argument at that time. Finally, after the defendant is done giving his closing argument, the plaintiff's lawyer gets the last chance to say anything to the jury, because he's the one with the burden of proof. So the plaintiff's lawyer will get up again and make closing argument, and make any other points he wants to make that he didn't already make, or re-emphasize points that he's already made in rebuttal to what the defense lawyer says. At that point, the case is given to the jury. Typically, the jury instructions that are actually written may be given to the jury also. The jury can take any exhibits that were introduced at trial back with them, and then they go back in the jury room and then they make a decision. The jury meets back there. They look at the evidence that's been given to them. They look at the jury instructions if they were given to them, and then the parties discuss the evidence between them. Also, the judge had given them a verdict sheet, which I failed to discuss. We'll discuss it now. The parties will also try and agree on a verdict sheet. If they can't, the judge will come up with a verdict sheet that the jury has to decide certain issues. In an accident case, it would typically be decided, who's at fault. Was the defendant negligent? Was the plaintiff contributorily negligent? And then, how much are you awarding? And then they'll usually have to itemize how much for past medical expenses, future medical expenses, how much for lost wages in the past, lost wages in the future, how much are you awarding for pain and suffering. So the jury's going to have that verdict sheet in the back that they're going to go over with when they're going over the evidence. At some point, the jury hopefully is going to come up with a verdict, fill in the verdict sheet, and report back to the court. If they can't agree on a verdict, they will let the court know that also. Then the case goes back out. All the parties come back in the courtroom, and the judge asks the jury if they have a verdict. If they say yes, then they ask the foreman to say what the verdict is. After that, if the lawyers want to poll the jurors to make sure they all agree with the verdict, they can do so. If they don't want to do that, they can waive that. And then that becomes the judgment in the case. So because you're unable to settle the case, whatever the jury says is what goes. Same thing it's the same thing if you elect not to use a jury, but you have a judge. Then the judge makes the decision in the case. The procedure is basically the same, except there's no jury instructions. And then whatever the judge says is what you're getting. So that, people are always told if you settle the case, at least you knew up front what you were getting, you were involved in the process. Once you try a case, it's now out of your hands, it's now out of the lawyer's hands, other than whatever evidence he presents and whatever arguments he makes. But ultimately, it's up to the jury. And if you don't like their decision after that, it's tough. So that's why the courts often encourage settlement, and why you're taking a chance, either one side is or the other one, when you're going forward with the jury. You try a jury case. In an accident case, the jury may give you more than what was offered, less than was offered, or nothing. For the defense side, same thing. If they force the case to go forward rather than settling the case, they may be sorry because the jury can come back with more, they can come back with less, or they can come back with the same. And as you know, typically attorney's fees get higher, the costs get higher when you try a case because you have to bring in the witnesses, you have to summons people, you have to pay the doctors to come in. So there's a lot of risk when you're trying cases. However, sometimes you have no choice. I want to thank you for listening. Again, my name is Mark Addis. I am located at 6 East Mulberry Street, Baltimore, Maryland, 21202. My phone number is 410-752-4878. My 800 number is 800-749-4878. My email address is mattis@attislaw.com. That's MATAS@ATASLAW.com. Thank you.